Welcome to the Exhibit A podcast.
Welcome to Exhibit A. Today, we have some power hitters here today. I'm going to say we have the power working moms, Allie and Casey. And I say that because both of you are, we've talked about this before, Casey, is both of you are able to handle a full-time profession and be full-time moms. And I don't know how you do that. You both have children currently in the home. So Allie, one thing that I heard about you recently, I didn't know this, but you get up like at 5 in the morning. You go work out before you come here?
I do. I get up at 4:30. My class is at 5:30. I'm done by 6:30, and I'm on with my day. But that's because that's the only time that's my time. There's nothing that can interrupt, very little that can interrupt with that time. In the afternoons, forget about it. It gets eaten up by work or kids or other stuff. But the morning is my time.
That is so incredible. I consider myself a morning person, but not that type of a morning person. I've never been able to work out at like 5 in the morning. Now, I know Casey would never do that because she's a night person.
I am a night person. I'm a night owl. I'm a little bit of a mess right now because I don't sleep at night anymore because I have an infant. But I strive to be like Allie and wake up at 4:30 in the morning.
Okay, well, you have no choice. I mean, you get that crying baby and your little toddler, and you've got to be up and stuff. So any tip? Just give us one tip that you could give to our working moms out there. Allie, what would you say as far as how you're handling it? What you would tell somebody that's aspiring to do it all, work, take care of kids, whether they're in school or whatnot? Give them one tip.
Forgive yourself.
Oh, I like that.
Forgive yourself.
What does that mean?
You're doing your best. You're doing your best. Your kids know you're doing your best. And show up, be there, be present when you're with them, but forgive yourself for the times where you feel like you can't go to every, for me, it's sports, right? I have to forgive myself that I can't go to every softball game. I try to get there for most of them, but 3 o'clock is not the easiest time.
Yeah. And
the ones I'm there for, I enjoy, and the ones that I can't be there for, I just have to let it go. It's hard. It's hard, but and it's everyone has their own things. But forgive yourself. You're doing a great job.
Okay. What about you, Casey? One tip.
One tip: self-care. If you don't fill your own tank, then you're going to be depleted, and you cannot give. You're a better person, friend, spouse, mother, employee, professional if you fill your joy tank and take care of yourself.
Okay, so I've got to follow up on that. What do you do?
Whatever it is you love to do, whether it's sit and have a meal by yourself, go to a movie, get a massage, go to an exercise class, self-care. That's what I'm striving to balance out in my life.
Okay, cool. Well, speaking of balancing things out in your life, do either one of you have any Super Bowl plans? For the people watching this, we are filming this on Friday, the day before Super Bowl weekend. What plans do you have?
We're just going to a friend's house, watch the game, a group of people. We're not super we're into college ball more than pro.
Yeah, I know that because I've sat next to you and Scott in many games. Now, Casey, you and I go to the same Super Bowl party, so I really don't need to ask that question.
Yes, well, I'm into the commercials, but I'm fortunate enough to get invited to a Super Bowl extravaganza. I think 6 years in a row. Food trucks, drinks, lots of people, games. It's definitely an event, and I'm very honored to be invited.
Yeah, I agree. I think that in America, we've created a new holiday, the Super Bowl day holiday. And the only complaint that I have is that we don't take a day off either before or after, particularly after because of all the food we eat.
Yeah.
Actually, there's two complaints. One is we don't have a recovery day afterwards, and two is that it's just another food day, and you get through November, December, you get into January, and you go, okay, now I can get back on the swing of things, and then Super Bowl day comes in, it's like, oh, here we go again. So,
well, Don, your name is on the wall, so if you want to take a recovery day, we will all forgive you.
I had a feeling that was going to come.
I was going to add this morning when you said the commercials, there was a story on NPR about the commercials, right? And this year, there's more commercials than ever targeting women.
Perfect.
because they really like Oil of Olay. I think has
For the Super Bowl.
for the Super Bowl, and Sarah Jessica Parker is
Well, that's smart.
in one. Yeah,
That's
So I
smart.
thought
Get
that was
everyone
interesting.
involved
Yeah.
in the party.
Cool. Okay. Well, let's go to the topic today. Today, I thought the reason why we brought the two of you together is that you have worked on a very similar type of case. I know you've even collaborated on a case or two. And I'll just lead into the topic this way: is I've been in the law, either as a police officer or as an attorney, ever since I was really 19 years old. I mean, I've been in it for a long, long time, and after a while, you think, I've seen everything, right? I mean, you would think that I would, and I'm sure that you think that way too, is you've seen a lot of cases, but you never do. There's always something out there. I remember when I was a DA, I was amazed that there's like cottage industries of defense attorneys that just represent people that commit welfare fraud, and you get these stack of cases, or the deadbeat dads, or whatever it is. I mean, there's just these little niches of bad behavior of people that we attorneys have to deal with. Coming into family law, I didn't think that I would see it, but there is a niche, and that is what I call the case of the stolen spouse. I know this sounds like a mystery novel to our viewers, but we know what that means. It's a case where, I guess I have to describe it by giving a hypothetical. And the hypothetical would be, and this is not based on any case that we've done, although I've borrowed some of the facts. Husband and wife both were previously married. The husband had children from his first marriage. During the second marriage, there's no further children. They enjoy a wonderful marriage. They're married for 25 years. He's much older than her. Let's say that he's 15 years older than the wife. And as he's in his late 70s, he starts having some medical conditions, and eventually he's in pretty bad shape. In fact, he loses his mental capacities to some extent. He has good and bad days, and he requires 24/7 care. So, at this point, the wife is caring for him with the help of two caretakers, and it's a very arduous thing for her. She's, wasn't really equipped for this, but she's doing the best she can. Husband's being fed. He's definitely being taken care of. One day, she opens up her mailbox and she discovers that she got a free trip to the Caribbean. And she thinks about it for a little bit, and she thinks, just for 1 week, if I could just leave for 1 week, it would just give me some time off. I've been doing this for a couple of years. It's really draining on me. The caretakers are great. He's got family. He probably wouldn't even know that I'm leaving. So I'm just going to go just to kind of restore myself. So she leaves. She leaves for a week, has a great time, comes back, and when she enters the door, she notices not only is the house half empty, but hubby's missing. He's gone. And there's a note on the table that says, "Dear," we'll leave out the first name, "we've taken Dad with us. You weren't taking good care of him. He's now living with us. If you need to talk to him, this is the phone number you could reach." That sound familiar to you? Mm-hmm. Now, I think what's interesting is for Allie, I didn't know this, but that's a fact pattern that you attorneys that deal with estate planning, you're familiar with this. I mean, it's not so unusual for you, but for Casey and I, it's a strange set of facts. I think what strikes me is the fact that the husband, who's now doesn't have the capacity anymore, if he were around, would he want that?
Right.
So let's talk first of all about conservatorship. I mean, in that fact pattern, the children, or one of the children, are going to try to get conservatorship over the father. What is a conservatorship, and how does it work?
So a conservatorship is it's like a guardianship for children, but it's for adults, and it's when the conservatee, who's usually the older person, doesn't have full mental capacity. And so another responsible person is appointed to basically care for them. And it's two-pronged. There's a conservatorship of the person. So that's, taking care of the health and the safety and that kind of stuff of the person. And then a conservatorship of the estate, which is, taking care of someone's money, finances, income, assets. So in your scenario, the spouse doesn't even have to leave the home. So there's an opportunity. I mean, I have cases that, and I think what's pretty universal about these cases is what you started with, is that it's a second marriage, right? So there's
Right.
children from the first marriage. So there's a lot of emotional stuff that's tied with this, right? And kind of that past family stuff that plays into a lot of it. But the children from the first marriage petition the court for conservatorship over dad. And so wife is in the home and right there, but all of a sudden this legal proceeding, someone's thinking that they're caring for their spouse, all of a sudden the court is involved in their life. And that's very scary and very intrusive.
Yeah. And so in the scenario that I put out, what is the wife going to have to do if she wants to fight the attempt to get conservatorship?
Object. And
What does the court consider?
the court considers the well-being of the proposed conservatee, so the older person. The court is going to look at what the assets are, how they're being spent for the estate portion, and then for the person portion, is the proposed conservatee being cared for? Is he clean? Is he going to doctors? Is he getting appropriate medical care? Do they have care in the home? Do they have proper care in the home?
Yeah.
Allie, as between the spouse and the children, is there a preference in the law?
Yes, the spouse does come first. Although in this area, there's a lot of discretion with the court.
Yeah, a lot of discretion. So, Casey, you know that from handling family law cases, children who are the product of a divorced family a lot of times don't like the new spouse or the stepmother or the stepfather. And that could carry on all the way into adult childhood. In some of the cases that we've handled, we've seen these facts play out a little differently, where the children then get conservatorship and they file for divorce on behalf of the parent. Were you shocked when you first saw that type of scenario?
Well, I've seen a couple of different scenarios that kind of are triggered in your fact pattern. Those cases are difficult, and I've been on both sides of the scenario. It's certainly, family law is already hard, but then add to it multiple adults being the adult children that are all chiming in to, what is in the best interest of your client, essentially. So it makes it even more difficult in that regard, because you're looking out for the interest of your client, and you have to be very careful about third parties chiming in and trying to push essentially their interests, i.e. their future estate.
Their financial interest, yeah.
Right.
Yeah, and so one thing we didn't talk about yet, Allie, is the fact that the children could also file for divorce on behalf of their parent. Now, that occurs either before or after the conservatorship is granted. It's after, right?
Yeah.
Okay,
Yeah.
so how do they get to do that? You talked about the conservator for their financials, the conservator for their well-being, but I didn't hear divorce in there. What's the theory behind that?
So when a person becomes conserved, it's a very serious process because their rights are being taken away, right? The court takes it very seriously. So actually, your right to manage your own finances is a lot easier. That right is easier to take away than the right to marry. That's a basic right that the court feels the court is very hesitant to take away. So, for example, I had a conservatee, this was years ago, who desperately wanted to marry his lady friend. And his lady friend was very obviously taking advantage of him. And the court appoints an attorney to represent the interests of the conservatee, and his attorney had to petition the court to give him permission to marry. And the court gave it to him, even though it was really not in his best interest. But again, and I believe that the right to marry is on the same level as the right to get a divorce, right? I mean, that's the same
Constitutional right.
constitutional right.
Yeah.
Yes, thank you. So it's almost hard to comprehend, right? Because we've seen it so much in our practices. I haven't done it yet, but now that we're talking about it, I'm thinking about it even more, that for couples that are in a second marriage, I'm thinking that I'm going to start adding a document to their packages if they come to me for planning. That's we do a nomination of conservator, but adding some language in there that says, if I'm not able to make my own decisions, I don't want any dissolution proceedings, filed on my behalf.
Oh, wow. Interesting.
I mean, I'll talk to my clients
would
about it.
that have any power in the court? The judge read that?
I believe
You think it
so.
would?
Yeah. I mean, the judge is still going to decide in the moment.
Yeah.
But if you have, some specific language, the judge will consider it that the person did contemplate this, when they did have capacity.
Yeah. So you just talked about the fact that people have the capacity to marry, and now we want to talk about the capacity to divorce. And I know, Casey, you and I have talked about this before, about in family court, you're not really dealing with the opposing party. You're dealing with the opposing party's child, either a son or a daughter.
Or your client.
Or your client, that's right, if you're on the other side, right. And with regard to the divorce is concerned, in my hypothetical, we're representing the wife, okay? And let's just assume that the son has obtained conservatorship, and then he files for divorce against our client. Is there any argument that there was no capacity, that the husband didn't really want a divorce? He doesn't want it now? Can we make that argument?
Well, in California family law, the threshold for filing a divorce really isn't a difficult threshold to meet. It's really just whether someone understands the consequences of financial orders that could be made. So the threshold for capacity to file divorce really isn't difficult. Now we start talking about the threshold to enter into contract. That might be a little bit more difficult. And certainly to the extent that a contract can be attacked on the grounds of duress, undue influence, those types of things, I think that there's a lot of vulnerability when it comes to those areas. So if you're in that situation, the analysis has, I think, at least 2 or 3 different steps. The first step to file, I think, is pretty easy, and there isn't much there. The capacity to file is something in the law that is not difficult to show. But then you get into the next steps, and then you have to look at each step in the case.
Yeah. So in a case that I had, I decided to take the deposition of the husband that didn't really have capacity, and it was interesting when I was questioning him about whether or not he even knew where he was. He didn't know what city he was in, didn't know what year. I think that he didn't even know when he got married to my spouse, or my client. It was like 1960, where in fact they were married in like 1989 or something like that. And then the what I consider the atom bomb question is do you want a divorce? And he started tearing up and crying, and he looked at my client and I love you. No, I don't want a divorce. Do you think that could play out in court?
As far as the capacity question?
Yeah, and whether he really wants a divorce.
I think so.
Yeah, I think so too. I mean, there is some case law that supports that, but it's interesting, and at that point it gets kind of ugly, right? Because really what you're doing is you're fighting somebody else. There's no opposing party. You're getting a child. It's really an estate planning issue is really what it is.
And I'll say that, again, in California, it's a no-fault jurisdiction, so all we need is one person to want the divorce, and if the respondent or the responding party is incapacitated or not, the person that files for divorce and wants the divorce is obviously going to be able to push the divorce through. So in your scenario, I'm not sure if husband was the petitioner or the respondent, but if he's the respondent, the divorce is going to happen with or without him. If he's the petitioner and he says, I don't want
the petitioner.
He's saying, I don't want a divorce.
Yeah.
I mean, I think that at least shows that there are other interests that are being pushed here instead
Yeah,
of
yeah.
his.
In my experience, I don't know about with you, Allie, but it's usually they're the petitioner. It's the son that's filing. Yeah, I think that the financial issue is really what is driving this more than anything else. And there are some things that could be done. Obviously, one of them would be an irrevocable trust. Could you speak of that at all, Allie?
Yeah. So our typical, what people are familiar with, a living trust is a revocable trust. So it you put your assets in, but you can change it. You could take assets out. You can do whatever you need to do. An irrevocable trust is exactly that. It's irrevocable for the most part, and it allows someone to do planning that they know is not going to be changed down the line. And in order to change it, you have to go to court, or you can build certain safeguards into it, but it does give you a little more. You lose some control, of course, but it gives you more confidence that whatever you decide to do in that trust is going to be carried out.
Yeah, and it seems to me that it could still be contested. I mean, it probably will be, right? Because the children are going to say he didn't have capacity, or she didn't have capacity at the time she signed that. So there could still be litigation, but assuming that somebody is found competent, that's a nice way of controlling the bad behavior, right? Or
Yes.
to preclude the bad behavior, I guess.
Right, and we have some safeguards too. So in addition to the attorney that's drafting the trust, we get what's called a certificate of independent review, which is just another attorney that can come in to interview the testate, the settlor of the trust, to just make sure, do you understand what this is? Do you know who your family members are? Do you know that you're giving, your assets to this person and not this person, that kind of stuff. So there are some additional safeguards, but you're right, anything can be contested.
Yeah. And then conversely, I know, Casey, you and I have dealt with a lot of people that are getting remarried, and they're like, God, I really want to leave something for my kids. I'm hypothetically, a 60-year-old man is remarrying, and he's got grown children, and he's only known his fiance for 6 months, about to get married. I mean, obviously a premarital agreement is something that may be considered in a scenario like that.
That's what we're seeing when we see elderly couples getting married. They both want to protect basically the estate for their adult children, and we see them coming in for premarital agreements on those issues.
Yeah. Okay.
And I like to do trusts for those people too, right? We do separate property trusts
Right.
where you can get creative. You can leave something for your spouse, but most of it for your kids, or
Vice versa.
I think, I do think that's a nice, to do the separate property trust along with a premarital agreement is really the gold standard.
Cool. Okay. Well, I think that we've had a very nice round discussion on that issue. I hope people find that it was helpful. It certainly is. Every time I talk to you, Allie, with regard to estate planning, I feel like light bulbs are going on because it's a foreign land for me. And then, of course, I love to hear Casey because she's so methodical and logical in her thinking. Okay, so we're going to lighten it up a little bit. Let's talk about a recent case. I think this is pretty recent. I saw this when I was eating breakfast one morning. I think it was last week. Dixie Chicks Natalie Maine's estranged husband's demanding $60,000 in monthly support. If he gets that, what does that say about her income, Casey?
I mean, she makes a lot of money. She makes a lot of money.
Yeah, the article says that she's worth $50 million.
Oh my gosh.
That's pretty good money. Boy, I tell you what, I'm a big fan of hers. I love the music. I don't know anything about her. I think she's a little bit political. I'm not a fan of political people that are also artists, but I love her music. And I'm happy that she's making all kinds of money. But here's what the article says. It says that the husband's saying that the Dixie chick, Natalie, is trying to force him into poverty by not paying him support. And he's now pleading for a judge to award him $60,000 a month. Later on in the article, it says that he earns $150,000 and he, quote, can't support himself and their 2 children. Casey?
I'm pretty sure there's a prenuptial agreement in that case.
There is. There actually is. Did you know that already?
I did. I just imagine there is. And I wonder if he is attacking the prenuptial agreement or whether that $60,000 a month request is in line with it. I'd be curious to know that.
Well, here's what it says. It says that Maines and the husband signed a premarital agreement before their marriage in 2000, and he has been challenging the validity of the deal. And so she's saying, hey, we'll have to wait to see if this is valid or not. So that would impact not child support, but spousal support, right?
Right, absolutely.
Okay. And so the other thing that I always find interesting here, since I've been handling family law cases, is that women do not like to pay spousal support any more than men like to pay spousal support. Have you found that similar? There's no difference, right?
I think that I equally have both men and women saying that's a hard pill to swallow when it comes to paying spousal support.
Yeah, and so it's not surprising today where we have more and more women in the workforce and households where women are actually the main breadwinner, that they're being asked to pay spousal support. And I thought this was kind of current. This article was current with what we're seeing in our practice here. It indicates that she's earns about $2 million a year and $172,000 a month. Now, from what I could tell, this is a California divorce because it talks about him moving out of his $12 million Brentwood mansion. And the poor guy's moving into a $7,000 a month rental in Venice. Oh. So I know. These poor people, man. I'm just crying my eyes out for them. But, the thing is that, $2 million a year, is that really a high income earner in the Los Angeles area?
I don't think so.
Yeah. Is that
$2 million a year? No. Mm-mm.
Okay, so she's not going to be able to make a claim that it's an extraordinary high child support order of $16,000 a month. You wouldn't think so, right?
I don't know.
Yeah.
No.
Okay.
It does. It just as an outsider on the spousal support issue, it challenges my
sense of fair play.
My sense of fair play, right? But isn't that so funny? Because of course it applies to both genders, right? Of course, that's the way the law is.
Yeah.
But it's I've noticed my thinking around it I need to adjust myself because
so you have to check your bias.
I do have to check my bias on that one. Yes.
Well, when I got into the family law area, I wanted to know why spousal support still exists today. Given that, it's usually two-income households, women are more into the workforce. Yeah, they may not be treated fairly in the workforce, but, with that. And when it boils down to it, it's really about thinking of spousal support as something that the marriage earned during the marriage. And the lower-income person is, really thrown out into the world while the other person is advancing in his or her career. Mm-hmm. And it's a case of trying to make it fair because usually it's a joint effort when the spouses earn money. So once I wrapped my head around that, I was okay with it regardless of which spouse paid spousal support. So, well, thank you very much for joining us again. This was a very interesting topic. I hope that I get both of you on the show again sometime soon.
Thank you, Don.
Yes, thanks.
And thank you for watching us on Exhibit A, and we'll see you next time.
Exhibit A is produced by David Lindley at the law offices of Donald P. Schweitzer in Pasadena, California. For more information, visit us online at PasadenaLawOffice.com and all social media platforms.